Hi, I'm David, on your mark, coming to you from Toledo, Ohio, the trademark capital of the world. Today I'd like to talk with you about registering your trademark. There are 51 ways to register your trademark in the United States. Every state in our United States has a trademark registration system. Some are better than others. But the one registration system that stands out above all 50 state registration systems is the federal trademark registration system, and it's administered in the United States Patent and Trademark Office. The answer is no, you do not. However, it would take me a long time to tell you all the horror stories that I know about people who have tried to register their own trademarks. I could even share with you some stories that I know about attorneys who were not trademark attorneys who tried to register trademarks for their clients. The online registration form asks fairly simple sounding questions, but it's very important to know why some of those questions are being asked so that the answers that you put into the application form get you where you want to go. In Ohio, the Secretary of State's office would be happy to register your trademark. The registration of your trademark in Columbus, Ohio has effect throughout the state of Ohio. A registration in the United States Patent and Trademark Office, on the other hand, is effective throughout all 50 states and territories of the United States. First, I'd like to clear up a misconception about registering your trademark. Some people even call it trademarking your name, but it's actually registration, and it's actually not a requirement for establishing rights in a trademark. In the United States, we have a use-based trademark system. When you use a trademark, and let me be clear, by using a trademark I mean putting it on your product or on the package for your product and then selling your product. You establish rights in that trademark by this use. These rights by themselves exist under something called common law. They don't have to be registered. They don't require registration in order to have effect and to be enforceable. If you use a trademark and have established common law rights in your trademark, you can stop someone else from using the same or a confusingly similar name by virtue of your common law trademark rights. So, kind of begs the question, why register? Well, there are several reasons, and some of them are compelling. A federal registration gives you the right to use the awesome R in a circle registration symbol. If you have not federally registered your trademark, you may not use the registration symbol. In addition to using the awesome registration symbol, in addition to using the awesome registration symbol, a federal registration for your trademark will put other people on notice of your claim to trademark rights in your trademark. That will help prevent other people from adopting your trademark or a confusingly similar trademark. It will also help the Patent and Trademark Office to keep other people from registering the same or a confusingly similar trademark. Federally registered trademarks can be registered with the U.S. Customs Service. I'm sorry, it's now Border Patrol and Enforcement. Not every trademark is eligible for registration in the Patent and Trademark Office. A mark must be used in commerce before it can be registered in the Patent and Trademark Office. In commerce means commerce that can be regulated by Congress. An example of this kind of commerce is interstate commerce. If you're shipping products from one state to another, you're engaged in interstate commerce, and the trademark that's on your product is eligible for federal trademark registration. If you're using a mark down at the corner for a fruit stand, and you grow your own fruit and you sell your fruit only at that stand, the trademark that you sell your fruit under may not be eligible. It would not be eligible because you're not using your mark in commerce. But with the expanding use of the internet to sell products, there are very few marks in use today that are not being used in commerce. If you're using a mark down at the corner for a fruit stand, and you grow your own fruit and you sell your fruit only at that stand, the trademark that you sell your fruit under may not be eligible. It would not be eligible because you're not using your mark in commerce. But with the expanding use of the internet to sell products, there are very few marks in use today that are not being used in commerce. Even though you could register your trademark with the Secretary of State in the states you're using your mark in, I suggest you'd be better off to register it in the Patent and Trademark Office and enjoy the benefits of federal registration.